Good afternoon. I'm Emily Taylor. Look forward to talking about guardianship and alternatives in Arizona. We're going to be talking today about a lot of different legal things, but I wouldn't be a good lawyer if I didn't do a quick disclaimer to say that the nature of watching this video or even asking questions does not create an attorney-client relationship, and you should always talk with a professional if you have questions about your situation. And so with that, we'll get started. For those of you who may not yet know me, my name is Emily and I'm an attorney. I've been licensed to practice since 2007. Grew up in a small town in the Midwest, but came out here to go to ASU, then went to law school at U of A. I'm a proud member of the Special Needs Alliance, as well as the Academy of Special Needs Planners and the National Academy of Elder Law Attorneys, as well as a number of other organizations. And we practice law in Phoenix. However, we're able to serve clients throughout the state of Arizona. So with that, we'll get started talking today about what things look like here in Arizona. I do want to give you a heads up if you haven't already explored our website. There are some digital resources that are available for download through our website. You can quickly get this QR code or go ahead and head on over to our website, but you may find that a guide to planning for your loved one with a disability is a helpful resource as we go through the different topics. So just a heads up that if you haven't already seen that guide, you can download it through our website. It's got some topics such as guardianship, supported decision-making, but also special needs trusts, benefits, a whole lot of things. So go ahead and get that downloaded if you haven't already. So today's topic, we're talking about young adulthood. Young adulthood means we've got this magical line in the sand. We turn 18 and suddenly all of our decisions have consequences. And so with that, we have to think through if we have a loved one who perhaps may not have the traditional timeline or may not be able to make certain decisions. We want to understand what options are available as we near their birthday, or perhaps have recently passed their birthday and what that looks like. That's because after 18, sometimes we run into situations where we've got issues related to government benefits, care services, healthcare decision-making, talking to doctors, things like that, let alone legal and financial decisions. And so it starts to become kind of overwhelming thinking about what this might look like for you and your family. Making decisions, obviously we all make a lot of decisions every day. And so in doing so, some decisions or choices we make have different outcomes than others, and some of them are much more serious than others. But when we think about making decisions at 18, what we think about are the big ones, right? So healthcare, suddenly a parent may not be able to attend doctor's appointments, let alone schedule them, may have difficulty communicating with health insurance providers, may struggle because suddenly that that DDD meeting with your support coordinator, your loved one, your child needs to participate and sign documents now that they're 18, and it changes a lot. So with that, we often also are still in education on some level, and that too brings up a lot of situations where decision making comes to front of mind, and where parents or grandparents or guardians may have been participating in a lot of those different areas. Suddenly we have a birthday and that all changes. So when we think about our loved one of the big parts that we want to consider is assessing their ability to make decisions, right? So we may find that between making decisions related to driving, voting, what to wear, how to manage medications, relationship decisions, there's a lot of opportunity for us to consider what that looks like. And when you think through your loved one and you analyze what you believe their capacity to make these decisions is, you may say, yes, they absolutely can do that. Sometimes it's a big maybe. Sometimes it's a not yet, but probably in the future. And of course, sometimes it's a no. They can't make those decisions. All of that's going to be different for each of you, but I encourage you to kind of spend some time pondering and maybe making some notes about what you believe that is appropriate. Another big question that we start to think about is vulnerability. Because sometimes if we have enough time and information, our loved one can make a decision. However, sometimes the decision that's made can be easily swayed by others. And so if there's people in their lives for good or bad reasons that may, step in and kind of bully their way into helping them make a decision, we have to understand what their ability is to advocate for themselves and their own personal wishes. And so as we speak today about all the different alternatives that come up, we want to kind of understand what each of those different areas look like and think about that in your situation. We're going to use a lot of language when it comes to court and guardianship. There's some of the terminology is perhaps what you would consider dated or inappropriate. Language is an always evolving thing, and sometimes the law is slow to catch up. And so you'll hear words like incapacitated and ward and things that perhaps bring about some bad thoughts or have negative connotations. And so I hope you'll forgive me if I use those terms, but a lot of times I'm just trying to mimic what we're going to hear in the law or what we might see in a legal document or a court matter. But some of the words also change state by state. So you really want to understand that if you're doing your own research, which you are if you're watching this, that you're understanding what it means in your state. So for example, here in Arizona, which is where we practice, a guardian is the person appointed by the court to make healthcare decisions, and a conservator is the person or professional appointed by the court to make financial decisions. But if you quickly go a couple hours over to California, the terminology all changes. You might hear conservator of the person and conservator of the estate. And so it's different nationwide. And so you really just want to understand what the language looks like where you're at. And like I said, we're going to be talking about Arizona today. So with that caveat, let's start thinking about the range of options we have. So I like to think about it in terms of kind of a spectrum. On one end of the spectrum, we've got adults who turn 18 and have complete autonomy to make decisions. The decisions they make, they hold the full consequence of that choice. And they're out there in the world making decisions all the time. And we've got nothing different about that. And so that happens at 18, whether we like it or not. And that's on one end. Now, on the other end of the spectrum, we have the complete different piece, which is when a court comes in and appoints a guardian. And this is a general guardianship where they say an individual is incapacitated. They're unable to make their own decisions. So the court, after due process, steps in, takes away their right to make decisions, and gives it to somebody else. Now, in between, we've got a number of different options. So you'll see things like powers of attorney, informal supported decision-making, often shortened to SDM, formal supported decision-making, limited guardianship, and then, of course, general guardianship. And so the decision we make for a loved one about which option we might pursue is not one size fits all. You need to think through, again, what capacity do they have right now and what are we looking to make sure is in place. So if we start, what we want to think about is for an adult, if they're able to make decisions and if they're able to understand the consequences of those choices, they also have the capacity to potentially put some paperwork in place that allows for them to delegate who can make decisions for them in the event they're unable to make those decisions themselves. And so these documents are commonly called powers of attorney. So we hear and we see healthcare powers of attorney, financial powers of attorney. In Arizona, we have a mental health care power of attorney. And so if you're watching this and you're a parent or a grandparent, perhaps you've put an estate plan in place. And as a part of that estate plan, it's likely that you've signed powers of attorney. I've signed them. I've signed these documents to say that if I can't make or communicate my own decisions, here's the team that can. And so it's really important because I want to make sure in the future, those people who need to make decisions on my behalf don't have to go to court. And so powers of attorney are great and wonderful documents. But one of the things to understand is that when I signed that power of attorney, or when you signed that power of attorney, it did not limit our ability to currently make decisions. So I can still go out and make all the good or bad decisions that I'd like, and I still suffer the consequences of those choices. And so it's important to think through as we're going through this, what that looks like. But these documents can be really helpful. And so powers of attorney do not prevent me from being able to make bad decisions, whether I like it or not. And so some of the upside and some of the downside. And that's what we're going to tend to do is talk a little bit about both sides of each of these different options. So one of the benefits of powers of attorney is it's empowering. I get to decide who can help me. I get to decide who can step in to make decisions. I might pick one of my siblings for my healthcare decisions, and I might pick another friend or relative for my financial decisions, but it's my choice. And I get to nominate them and I get to grant them the powers I want them to have. Powers of attorney are pretty inexpensive. The state of Arizona has healthcare directives available for free through our attorney general. A lot of times you can find inexpensive forms online. And even if you work with an attorney on these powers of attorney, they're still going to be relatively inexpensive. They're easy to obtain. So if I do a quick Google search of healthcare directives, pull that from the Attorney General, have some ink in my printer, and are able to print the forms, I can have a power of attorney in place probably within a half an hour. Now, a power of attorney does have certain requirements related to witnessing and notary. So you want to understand what that looks like, but it's really easy to get that put in place. It's also quick. And therefore, it's easy to change. So if today I put in my powers of attorney and I say my brother gets to make all these decisions, but then tomorrow he makes me mad or he makes a personal decision I didn't like, well, great. I can download a new set and update who I want to make those decisions. Now, on the other hand, that's also one of the downsides of powers of attorney if we're hoping that this power of attorney will serve in the way we want it to for our loved one. And that's because individuals therefore can easily revoke those. So if we're dealing with an individual who perhaps is subject to vulnerability, right? Subject to somebody coming in and taking advantage of a situation, or the kids these days say love bombing them, right? If they suddenly had a romantic interest come in and say, why do you have your parents helping you out? I'll do it, right? Well, that's a downside of the powers of attorney because that vulnerability leaves these documents open to not necessarily working when we need them the most. It also remains the presumption that the individual, your loved one, can make their own decisions, and the consequences of that choice does not change at all. So I often talk a lot about meeting a love interest, going down to the courthouse to get married, driving shortly thereafter over to the car dealership, signing a loan for a vehicle, and that happening. And when that happens, if it's me as an adult without any documentation, or even if I have powers of attorney in place, I am now legally married with a lot of money owed to a car dealership at who knows what interest rate, whether or not I can pay it. So the power of attorney does nothing to prevent a situation like that from that occurring. Those contracts, that marriage, they are all valid. So far, so good. And I see a few more people have joined us since we first started. So please feel free to put questions in the Q&A through the chat function, or excuse me, through Q&A, and I'll address them at the end. Now, if we jump all the way to the other end of the spectrum, we talked about guardianship. And so guardianship is appropriate or may be appropriate for an adult who does not have the capacity to sign powers of attorney and really struggles to understand how to make decisions or be able to communicate how they want decisions to be made. So the guardianship is when we invoke the court and ask them to become involved. We do that through a series of pleadings. We petition the court to start a guardianship process. And in doing so, we're going to have a number of steps we have to take. And at the outcome of this is potentially the appointment of a guardian. So if the court finds that the evidence matches the need and that a guardian is appropriate, what we're asking is to take away the rights of an individual and give those rights to somebody else to make decisions on their behalf. Now, guardianship, like I mentioned, is in Arizona specific to personal, medical, and education decisions for an adult. We'll talk a little bit about the finance moving forward, but it's a big deal, right? It's going to be allowed for the guardian to decide where this person lives, what they do for work, what kind of medical procedures and medications they have, whether they can get married, sometimes whether they can drive, whether they can vote, things like that. So it's a big deal. And so with that, we've got a series of steps that have to be taken. And that is because we want to make sure that this individual and their rights are protected. And so the court is under an obligation under the Constitution to make sure that we're not inappropriately taking away somebody's rights. Now, what that means for us is that the process is going to require that the petitioners, the people asking the court to get involved and asking for the guardianship to be granted, that they've met a lot of different steps and requirements. And at the end of the day, this is important and this is really good, because if somebody were filing a guardianship over me, I would want to make sure that all of these steps are followed and that it's absolutely certain that it's appropriate. So first and foremost, we're going to talk about a health report. Now, this report is a very specific form from the court that provides certain questions that do allow for answers to be provided by a medical professional. Sometimes that's a doctor, sometimes that's a nurse or a nurse practitioner, but you want to make sure that you've met the requirements of the court. Now, these answers are important because the court's really going to rely on this as evidence. That report gets filed with those pleadings, those petitions, those affidavits, the other forms that the court is going to require. And the court then sets a hearing date. Now, oftentimes that hearing date is going to be 60 to 90 days out. So it's not immediate. Things don't necessarily go quickly. And that's because between the time we file everything and the time we show up and are in front of a judge, although these days it's mostly virtual, the court's going to require that we've taken a couple of other steps. So one of those things is we're going to have a court investigator appointed. So the court will appoint somebody to interview the parties, sometimes visit the home, visit the school, and put together a report so the judge can see that certain things have been met or evaluated. The ward or the potential ward is also going to be given their own attorney. Now, this court-appointed attorney is somebody that the court appoints. There's a number of attorneys in that county that have been kind of chosen for this short list of who can do this, and it's random. But they're going to represent the interests of the person subject to the guardianship. And their job is to meet with them and understand and share the rights that that individual has, to object to this hearing, to provide their own evidence, etc. And then they're also going to represent their interests before the judge at the time of the hearing. So it's very, very important that those two parties, the court investigator and the court-appointed attorney, are in place and that they appropriately can advocate for what's in their client's wishes. Now, the hearing, like I said, it's 2025 now. Since COVID, we've largely moved to a virtual format. Some counties do it slightly different, but in Maricopa County, for example, almost certainly your initial hearing for the guardianship will be virtual. And so attending that hearing is important because the judge is going to be able to ask questions, the lawyers are going to be able to ask questions, and the individual subject to the guardianship is going to be able to state their position. Now, if there is no objection, if things have gone smoothly, we have all the information, nobody's objecting, then it's likely the court will hear the whole case during that initial appearance and make their rulings during that time. On the other hand, if a party is objecting or has concerns, then often that is just the first of several hearings. Now, one of the other big things that's going to come up is what we call notice. And that is a process to determine who's entitled to understand and know that this process and this hearing is going on. And we're going to talk about that in a little bit more depth. So long as notice has been done, there are no objections or any objections have been overcome, then the court will likely make a ruling during that initial hearing. And that's appropriate. Now, in some cases, it may not be appropriate for your loved one to attend the hearing. So if they've been personally served, sometimes they can still just go to school or go to their day program or go about life without attending the hearing, so long as their attorney believes it's appropriate for them to not participate. Now, once the court makes their order, if that is appointing a guardian, then there are follow-up steps, things like getting letters issued. There will be a minute entry issued by the court, all sorts of things to formalize the process and demonstrate the approval of the guardianship. So I imagine There are law school courses, there are continuing education. I myself could talk about all the different steps of guardianship probably for several hours. So this is a very high level overview. A lot can go on, but that's kind of the big picture, right? That's going to be the timeline to make sure everybody's in place and understands what's going on. Now, the upside of a guardianship is that at the end of the guardianship, that proof of guardianship, our letters, the documents that demonstrate somebody's been appointed, are well recognized. DDD knows what to look for. The doctors know what to look for. Schools, for example. So there's a formality to it that does allow for that decision making to carry on. And it's important because if it's necessary, it's protecting the individual who can't make their own decisions. The other good news is that in Arizona, our annual reports of guardian are very simple to put in place. So it's essentially a short worksheet that's several pages long, but easy questions that's going to report to the court how often you've seen them, if they've seen a doctor, what changes have occurred, should the court reconsider this. And attached to that needs to be some very basic medical documentation. So not the original report we file up front, but anything that might indicate that the doctor has seen that individual in the prior year. That gets mailed in or dropped off once a year, and things carry on. As I've heard several judges or commissioners mention, as long as you do what you're supposed to do, you're not going to be in front of the court very often. And the upside is it changes that legal presumption. So it's not to say that logistically somebody can't still go to the courthouse, get a marriage certificate if somebody overlooks something, still go to the car dealership and sign that loan. But what it means is that those decisions are voidable, meaning they're not necessarily going to hold the weight of the other things if we didn't have guardianship in place. And so that power means that the decisions that are made, even if they're made, they don't have the consequences that we've dealt with without the guardianship. Now, the downside, of course, is that this can feel overly restricted or restrictive for high functioning individuals. And high functioning, again, is some language that perhaps is becoming or sounding a bit dated. But what we mean by that is for individuals who may make decisions slowly, or have trouble communicating their decisions or wishes, but can still, with the appropriate time and support, make their own decisions. It can also be or feel expensive or stressful. So a lot of times people want to hire lawyers to go through the process because doing it on your own can feel overwhelming. It is very much an option to be able to do it on your own. Our courts do provide forms and a way for that to proceed, but it can feel expensive if that's something you want to have, and it can feel stressful. First of all, a lot of times it's really emotional. We don't want to have to think through what that looks like in terms of meaning for our child, and so it in a lot of ways can hold a lot of that emotional weight. Now, real quickly, we talked a lot about guardianship. We're not going to talk a lot about conservatorship, and that's because today we're talking often about young adults. And in talking about young adults, most young adults don't have a lot of money. And so when we think about conservatorship or guardian of the estate, as it's known in some states, but conservatorship here in Arizona, it's a very similar process, but it's to appoint somebody to make financial decisions. Well, oftentimes, if your loved one is receiving benefits through Arizona long-term care system, so All-Tex or DDD, or if your loved one is also potentially going to be or has been receiving benefits through SSI, they're required to have less than $2,000. And so since they have less than $2,000, and even if they have Social Security, the court does not necessitate a conservatorship for that, because the guardian does have certain nominal rights as it relates to money. And with the Social Security, because there's the process of appointing what's called a representative payee or a rep payee, they're not going to appoint a conservator. So it's unlikely that if your loved one is receiving services through DDD Altex or SSI, or in general just doesn't have any financial assets or resources, we don't need to worry about a conservatorship. Now, we've talked about both ends, right? We've talked about turning an adult and maybe having powers of attorney in place, and then we've talked about general guardianship. And now, as we start to kind of close the gap and see what other alternatives there are, we're going to move in that direction. And so, one of the things that has, I think, in the last since I've been practicing over the last 18 years, become more popular, but also become more well recognized with the court is what's called limited guardianship. Now, by law, guardians are forced or required to have the least restrictive alternative in place. Guardianship is only supposed to be necessary when it's necessary. But with that, with a limited guardianship, what we're allowed to do under the law is specifically carve out certain decisions or rights that the individual can maintain. And so that means that with a limited guardianship, maybe to start, or maybe after the guardianship's already been in place, we're restoring that individual's rights to certain things. And so commonly we're addressing voting, whether or not the individual can vote. Driving is another common one because sometimes people or individuals are able to operate a motor vehicle. Marriage, relationship decisions, sometimes it's important just to limit the ability to contract or government benefits. All sorts of different things can be structured. But what it allows for us to do is have some process that looks a lot like a general guardianship, but that's more specific to your situation. So one of the upsides, one of the benefits of a limited guardianship is it's more empowering, right? We get to demonstrate and reflect in the court process what this individual is able to successfully do. It is the least restrictive option because we've been really specific about what that's necessary and what's not. Protecting those rights to drive and vote are very important because they often are kind of synonymous with becoming an adult. They grant still an authority. And so again, after you go through the process of a limited guardianship, you're still going to get letters that demonstrate or outline what your powers are. And so the doctors and DDD and the like are going to recognize this documentation. And then it's going to allow for the court to have an open case. And so if we have a limited guardianship and in some ways things kind of regress and we need to go back and add additional restrictions or limitations into the guardianship, we're able to do that. Now, the downside is we still have all this due process protection. I actually think that's a big upside, right? It's important that we're protecting these young adults, but it can feel, again, overly burdensome in some cases. The fees and costs are going to be the same, so you're not going to see any difference there. And the annual reporting requirements are going to be the same. So some good, some bad, a little bit of both, but we can see how this might be a good option for some of the individuals in our lives where we've changed that presumption of decision making on certain pieces, but we've maintained and retained other rights to make decisions. Now, as we continue into the middle, we've now got over the last couple of years, kind of this term supported decision making coming more into our vocabulary. And supported decision making has frankly always been there informally, right? I've made 100 decisions so far today, but I've had input. My dog helped me decide what time I was going to wake up. My best friend decided what I was going to do tonight for dinner because we're going out. We have other people give us information, share, oh, this restaurant looks good and this looks good. Now you decide, right? That's a supported decision. Some of those are fun. Some of those are harder, right? If I had a big medical decision I had to make, I am going to look to my family, my friends, my medical providers. They're going to help me gather information about treatments that I should decide. Now, at the end of the day, I'm still making that decision, but I've informally gathered a group of people, individuals and professionals who can help me make decisions. But decision making is all mine. So instead of a guardian making decision, we're talking about supporters helping the individual make their own decision. Now, almost 2 years ago, we got supported decision making in the law. So Arizona passed statutes that formalized supported decision making. And so in the law, or as it relates right now, we've got the option to have a written witnessed agreement. This is nice. It kind of fits along the lines of those powers of attorney and often goes hand in hand with powers of attorney. And it formally structures who my supporters are, what decisions they can help support me make, things like that. It can still be an informal arrangement. It is a part of person-centered planning, which across the world is more and more important, right? We want to understand and maximize the individual's ability to make decisions for them. And it's another less restrictive alternative to guardianship. So, under the law, supporters can assist an adult in understanding the options, responsibilities, and consequences of decisions. So, a lot of times, when we're a teenager and we say, I'm going to go do this, I'm going to go to North Dakota for college. And my parents turn around and say, North Dakota, have you considered that it's below freezing and you grew up in the desert? Have you considered that it may be really hard for you to get to an airport to come home or travel? Have you considered the tuition, right? They're going to make a lot of those questions. They're going to help me understand and consider all the different options I have available. Now, the reverse is true for me. I was in the Midwest and I decided to come to Arizona, but you still have a lot of different input and support. And so understanding options, the responsibilities, and the consequences are really helpful. And that's something that this formal and informal supported decision making allows us to do. It also allows the adult in accessing, collecting, and obtaining information. So getting medical records, getting school records, and a lot of times helping use those records. It allows in understanding, assisting in understanding. So, right, providing feedback, giving that back and forth, and assisting communicating. So some adults have the capacity to make decisions, but again, struggle to find a way to communicate that. And so long as the individual is still making their own decision, supported decision making can be a good way to assist in communicating what those decisions look like. What can the supporters not do? Supporters cannot sign legal documents on behalf of the adult or bind them in a legal agreement. They, of course, cannot intimidate or deceive the adult to gain the supportive decision-making agreement or any of the decisions made under that. They can't receive compensation, and they can't continue in their role under the supported decision-making agreement in the event later guardianship is established. The consequences of doing bad things under a supported decision-making agreement are criminal prosecution and civil penalties, which is good. At the end of the day, though, supported decision making is not making a decision that's somebody's best interest. It is not substituting your judgment for theirs, and it is not somebody else making a decision on that person's behalf. So we've really got to understand that the decision making doesn't change. It is true support in that way. Now, the upsides to this, again, very empowering, very flexible. It provides and creates a lot of autonomy. It creates a lot of opportunity for learning on how to make decisions, and it increases that independence over time. So that's all ideal. The downside, the formal supported decision-making and a decision-making agreement is still newly effective. So it's not been around for that long. So sometimes that means doctors aren't going to understand. DDD may not understand. They may not respect or validate that, and they may still go their own way. And again, it doesn't prevent our individual from contracting or making decisions and having to deal with the consequences of those. So there's a lot of upside and a lot of downside, but it is a very important element that is now available to us in Arizona. And so as we have a young adult or somebody nearing young adulthood and we're thinking about what is going to work for our situation and our family, it's definitely something to consider. Now, one of the things that you may see is that supported decision-making, unlike guardianship, you don't necessarily need an attorney. Now, do I think it's a good idea? Of course. I think it's helpful to really understand in your circumstances and help implementing a formal supported decision-making agreement. But what I've put together is a supported decision-making kit. And again, you can find that on our website. And in that kit, you're going to have and receive a supported decision-making agreement that you can fill out based on your needs or your loved one's needs. It's going to have some information. It's going to have some communication prompts. So how to talk to people about becoming a supporter, how to communicate the supported decision-making agreement to medical professionals, to DDD, and a lot of that stuff. And so it's got a lot of resources that if this is something you're considering, you may find valuable. Now, this one isn't free. The other ones are, but you can learn more and take a look there and see if that's something that you think you're going to implement might be helpful in understanding what that looks like. So with that, we've kind of closed the gap, right? We have a better sense of our understanding. And now the piece is what should I do? And sometimes that's why it's appropriate to come in for a consultation, to meet with me or my team to talk about your particular situation, to share some experience about what teenagehood has looked like in your household. But there are some frequently asked questions I kind of want to go through. So the first one is related to notice. So when we were talking about guardianship and limited guardianship, as well as conservatorship, under our law, there are notice requirements. Who is entitled to be notified of this procedure? So first and foremost, the alleged incapacitated person. They have to be personally served. We have to be able to demonstrate to the court that they've been given a copy of the petition as well as a notice of the hearing, that they have an opportunity to show up and to state their position. Now, their spouse, a lot of times when we're talking about young adults, there may not be a spouse in place yet, but it happens from time to time. Their parents, now that can be kind of loaded, right? Because there are a lot of modern families. We may have some elements of divorce, adoption, parents that may or may not have ever been a part of the child or young adult's life. And so we really have to understand what that means and who's entitled to notice. And in the end, they're entitled to notice unless parental rights have been severed. And so even if they've never showed up to a birthday party or haven't had a relationship for a number of years, we still have to demonstrate to the court that they've been given an opportunity to be aware of this. And so there's different ways that can happen. But it's another thing that specifically you want to understand so that you can make sure you've met that notice requirement prior to showing up to your hearing. Now, again, unlikely in our scenario, but they're adult children. And then anybody who has care and custody of the alleged incapacitated person. So from time to time, under certain circumstances, an individual may live outside the home in a group home or a residential setting, or may live with a family friend or grandparents, but not formally their guardians. And so just needing to understand who's entitled to notice is going to go a long way in making sure that your guardianship or limited guardianship goes smoothly through that process. One of the other questions is people ask, what does guardianship cost? And again, you can file on your own. So the counties in Arizona do have the resources and pleadings available to make sure that the guardianship's in place. Hiring an attorney is going to depend on the attorney you hire. So in our office, we do represent parents, grandparents, and other adults in pursuing guardianship. As long as it's uncontested, we're going to do it on a flat fee, meaning you know what it's going to cost up front and we know what it's going to cost. And in doing so, we do set up the option to set up a payment plan if that makes it more doable or digestible. Now, do you need an attorney? Not necessarily, but the factors that you want to consider are your comfort level, right? How good are you with paperwork and courts and understanding how things happen? The time you have available to address this, because again, this is going to take a while. In Arizona, you're allowed to file for guardianship 6 months prior to an 18th birthday. It's not required that that be done. You could file the day before their 18th birthday, but it does mean that you're not going to have a hearing before their 18th birthday. So that's why we have that 6-month period. So if you can file 6 months before, then you're going to have the hearing and have most certainly everything done before their birthday. So there's no lapse in coverage. But the time you have available to address to this to make sure it gets timely filed, that you've gotten all the steps taken care of, is going to impact whether or not you think an attorney would be helpful. And then generally kind of how complicated are things? Are there rights we're trying to preserve? Are we trying to do something unique through a limited guardianship? Or are the parents divorced? Is there potential that people might be fighting or the child, young adult might object? All things we want to consider as we move through this. Excuse me. Some tips if you're going to try to do it on your own. So first and foremost, you need to file in the county that the young adult is in. So if your young adult lives in Tempe, we're going in Maricopa County. If your young adult lives in Apache Junction, we're probably going in Pinal County. But we really need to understand which county what they live in and where we need to apply. Each county has the forms available, almost all in Arizona through their website. Sometimes you need to contact a law library, but they've made it pretty easy to download these. Now, in Maricopa County, for example, you're going to download packets, and these packets have instructions and forms. And they kind of break it up into steps, but frankly, my advice is to download all of the packets so you can understand all of the steps. Read through it all before getting started. Of course, my recommendation is be kind to court staff and to court appointed counsel. They can go a long way in helping. They can't give you legal advice, but they can do a lot to help make sure everything gets done and done appropriately. And then, of course, be organized. There's a lot of paperwork. There's a lot of things going on. And so if you're really organized, it makes things a lot easier for you to feel comfortable that when it comes time for your hearing, you're going to be ready for whatever the judge might need. And so those are just some kind of quick tips. Like I said, we've got resources available for download. If you joined us midstream, there's a free guide to planning for your loved one with a disability that does have some additional resources on guardianship, conservatorship, supported decision-making, but also special needs trusts and some other elements that you may just want to flip through. And then, of course, there's other resources through our website that you can go explore, but I recommend that if you're interested in learning more. We also have, through our YouTube channel, other recorded webinars that you may find helpful if you found today helpful, but I encourage you to keep learning. And with that, I want to say thank you. And I'll say that just because primarily I know it's a lot to digest. It's a big decision for you to think through and understand what that looks like. And so thanks for taking the time, not only listening to me, but also for caring about what happens to your loved one and taking that step to better understand what's appropriate for them. We are always happy to help you. This is our guardianship team right now, myself, my certified paralegal Jessica, and Matthew, who is our legal assistant. We have other members of our firm, but we're the three that primarily work on these matters. And so if you have any questions, I encourage you to schedule a consultation and learn more about our services. But you're always welcome to reach out.